Justice Kavanaugh's long litany of cases in which we've overruled precedent, and we have. Yet you did call this unprecedented. As I see the structure of the Constitution,
I'm live right now.
The body of it is the relationship of the three branches of government.
So if you have any input into this and you want to join the Discord, feel free to join the Discord.
Of the federal government to the state.
We'll see what happens, see if I can get all the
and through our incorporation of the 14th Amendment of the state vis-a-vis the individual, it's the federal government and the state's relationship to individuals. And I see the Bill of Rights, including the 14th Amendment, as basically setting the limits, giving individual freedom to do certain things, and stopping the government from intruding in those liberties, in those Bill of Rights, correct? Of all of the decisions that Justice Kavanaugh listed, all of them virtually except for maybe one, involved us recognizing and overturning state control over issues that we said belong to individuals. The right in Miranda to be warned was an individual right, correct?
That's right, Justice Sotomayor, and I think that that is a key distinction with the list of precedents that Justice Kavanaugh was relying on. I think that there are really two key distinctions, and the first is that in the vast majority of those cases, the court was actually taking the issue away from the people and saying that it had been wrong before not to recognize a right. And I think that matters because it goes straight to reliance interests. Here, the court would be doing the opposite. It would be telling the women of America that it was wrong, that actually the ability to control their bodies and perhaps the most important decision they can make about whether to bring a child into this world is not part of their protected liberty. And I think that that would come at tremendous cost to the reliance that women have placed on this right and on societal reliance and what this right has meant for further ensuring equality.
Reliance point is a good point, and this may be my fault. I'm talking about pages 854 to 863 in the Casey case, and I've already used up too much time. I can't read those pages out loud. But they do not include the list that Justice Kavanaugh had. They do include two. One is Brown, and the second one is West Coast Hotel versus Parrish.
There we
and
go.
You could add the gay rights cases as a third, which would fit the criteria. But there are complex criteria that she's talking about that link to the position in the rule of law of this court. So all I would say is you have to read them before beginning to say whether they're overruling or not overruling in the sense meant there, calling for special concern. Now, they say in those, maybe I'd mention too. Wait a minute. Of course, Plessy was wrong when decided, but just a minute. Also remember, Plessy said that separate but equal was a badge of inferiority. No, they said it isn't. Well, all you have to do is open your eyes and look at the South, my friend, and you will see whether it was or it wasn't in 1954.
Speaking chat?
And they made a similar point.
I'm not.
They said, "Are you going to sit here in the middle of the Depression and tell me that Lochner, with its other cases, and pure, just about pure laissez-faire, that we can run the country that way?" I mention that because I want people to read those 15 pages with care. And that's why I said that. If you had anything to add to my plea to read it, please do.
Well, Justice Breyer, I agree completely. I have read those pages and reread them many times, and I think that this is actually another key distinction from the cases that Justice Kavanaugh was referring to, and that is, as I understand those passages in Casey, the court carefully walked through each and every stare decisis factor that this court focuses on. It looked at workability of the viability rule, doctrinal underpinnings, legal and factual developments, and critically reliance interests, and down the line it found that the case for reaffirming Roe was overwhelming. And in that situation, when every factor that the court consults to determine whether to retain precedent counsels in favor of retaining it, I think Casey properly perceived that a decision to overrule nevertheless, perhaps based on conclusion that the justices thought the case was wrongly decided in the first instance, would run counter to the ability of stare decisis to function as a cornerstone of the rule of law in this context.
Is it your argument that a case can never be overruled simply because it was egregiously wrong?
I think that at the very least, the state would have to come forward with some kind of materially changed circumstance or some kind of materially new argument, and Mississippi hasn't done so in this
really?
case.
So suppose Plessy versus Ferguson was re-argued in 1897, so nothing had changed. Would it not be sufficient to say that was an egregiously wrong decision on the day it was handed down, and now it should be overruled?
It certainly was egregiously wrong on the day that it was handed down, Plessy, but what the court said in analyzing Plessy to Brown and Casey was that what had become clear is that the factual premise that underlay the decision, this idea that segregation didn't create a badge of inferiority, had been entirely mistaken.
So
and here the state
is it your answer that we needed all the experience from 1896 to 1954 to realize that Plessy was wrongly decided? Would you answer my question? Had it come before the court in 1897, should it have been overruled or not?
I think it should have been overruled, but I think that the factual premise was wrong in the moment it was decided, and the court realized that and clarified that when it overruled.
So there are circumstances in which a decision may be overruled, properly overruled, when it must be overruled, simply because it was egregiously wrong at the moment it was decided.
Well, I think every other stare decisis factor likewise would have justified overruling in that interest, that actually it would run counter to any notion of reasonable reliance, that it was not a workable rule, that it had become an outlier in our understanding of fundamental freedoms.
There was a lot of reliance on Plessy. The South built up a whole society based on the idea of white supremacy. So there was a lot of reliance. It was improper reliance. It was reliance on an egregiously wrong understanding of what equal protection means. But your answer is, I still don't understand. I still don't have your answer clearly.
Can a decision
be overruled simply because it was erroneously wrong, even if nothing has changed between the time of that decision and the time when the court is called upon to consider whether it should be overruled? Yes or no? Can you give me a yes or no answer on that?
Argument of objective morality.
This court, no, has never overruled in that situation just based on a conclusion that the decision was wrong. It has always applied the stare decisis factors and likewise found that they warrant overruling in that instance. And Casey did that. It applied the stare decisis factors. If stare decisis is to mean anything, it has to mean that that kind of extensive consideration of all of the same arguments for whether to retain or discard a precedent itself is an additional layer of precedent that needs to be relied on and can form a stable foundation of the rule of law.
General, you've talked a number of times about the reliance interests here, and I think I'd like you to say a little bit more about that, because, you know, sometimes when we talk about reliance interests, it's like there's a rule of law, and you look at it and you say, oh, somebody will enforce my contract because of this rule, and it has a very kind of grounded quality to it. And as Casey talked about the reliance interests here, they're a little bit more airy. And I just wanted to get your sense of what are the reliance interests here, and how do they cash out on the ground?
Well, there are multiple reliance interests here, as I think Casey correctly recognized. Casey pointed to the individual reliance of women and their partners who had been able to organize their lives and make important life decisions against the backdrop of having control over this incredibly consequential decision whether to have a child. And people make decisions in reliance on having that kind of reproductive control, decisions about where to live, what relationships to enter into, what investments to make in their jobs and careers. And so I think on a very individual level, there has been profound reliance. And it's certainly the case that not every woman in America has needed to exercise this right or has wanted to, but 1 in 4 American women have had an abortion, and for those women, the right secured by Roe and Casey has been critical in ensuring that they can control their bodies and control their lives. And then I think there's a second dimension to it that Casey also properly recognized, and that's the societal dimension. That's the understanding of our society, even though this has been a controversial controversial decision,
insane.
that this is
What
a
a
liberty
stupid
interest
argument.
of women. It's the case that not everyone agrees with Roe versus Wade, but just about every person in America knows what this court held. They know how the court has defined this concept of liberty for women and what control they will have in the situation of an unplanned pregnancy. And for the court to reverse course now, I think would run counter to that societal reliance and the very concept we have of what equality is guaranteed to women in this country.
It is certainly true that there can be some planning by some people about pregnancy. People who are raped don't have a choice, whether it's by an outsider or their own husband. And not everybody can afford contraceptives, contrary to your adversary's brief.
Not everybody.
In fact,
if you can't afford contraceptives, you can't afford an
19%
abortion.
of the women in Mississippi are uninsured, so they don't have money to pay for contraceptives. So, but why their point in their brief was, contraceptives, if you use them, the failure rate is very small, et cetera, how can there be real reliance? So could you address that issue?
Of course. So first, this is not a new circumstance since Roe and Casey. Contraceptives existed in 1973 and in 1992, and still the court recognized that unplanned pregnancies would persist and deeply implicate the liberty interest of women. But I think even on the facts, the state is mistaken here. A contraceptive failure rate in this country is at about 10% using the most common methods. That means that women using contraceptives, approximately 1 in 10 will experience an unplanned pregnancy in the first year of use alone. About half the women who have unplanned pregnancies were on contraceptives in the month that occurred. And so I think the idea that contraceptives could make the need for abortion dissipate is just contrary to the factual reality.
You also mentioned, or maybe it was your co-counsel,
Who's speaking right now?
Life changes.
I really wish we had video, or at least like some sort
That's exactly right, Justice Sotomayor, and I think that this is responsive as well to the questions that the Chief Justice was asking about, in particular, the impact of enforcing a 15-week bar in this case. The court has always looked at that issue by looking at the people for whom the law is a restriction, not those for whom it's irrelevant. So the question is, why would women need access to abortion after 15 weeks, and what is the effect on them? And there are any number of women who cannot get an abortion earlier. They don't realize that they're pregnant. That's especially true of women who are young or don't haven't experienced a pregnancy before, or their life circumstances change, as you referred to, Justice Sotomayor. They lose their job, or their relationship breaks apart, or they have medical complications. Or for many women, they don't have the resources to pay for it earlier. It takes time for them to raise the money or make the appropriate logistical arrangements to be able to take time off work and travel and have childcare. And for all those women in this category who need access to abortion after 15 weeks, the fact that other women were able to exercise their constitutional rights does nothing to diminish the impact on their liberty interests in forcing them to continue with that pregnancy.
Thank you.
General, following up on that, would that argument be true in terms of viability as well? In other words, your discussion of the reliance interests and the ability of women and men to control their lives in reliance on the right to an abortion, the argument would not be as strong, I think you'll have to concede, given what we're talking about, which is not a prohibition, it's a 15-week line. Is that right?
Yes.
You have to hypothesize people who have planned their lives according to a 24 or whatever week limit it is, but not a 15-week limit on abortion, right?
Well, I don't think the court has ever analyzed reliance with that kind of parsing. I think here the force of the viability line is that it's clearly demarcated the scope of a woman's protected liberty interest in this context. And the state is not actually asking this court to replace it with a clear 15-week line that would provide some measure of continued protection for this right. They're asking the court to reverse the liberty interest altogether or leave it up in the air And if that were to happen, then immediately states with 6-week bans, 8-week bans, 10-week bans, and so on would seek to enforce those with no continued guidance of what the scope of the liberty interest is going forward.
Well, that may be what they're asking for, but the thing that is at issue before us today is 15 weeks. And I just wonder what the strength of your reliance arguments, which sounded to me like being based on a total prohibition, would be if there isn't a total prohibition. And as far as viability goes, I don't see what that has to do with the question of choice at all.
Well, I think as Casey emphasized in reaffirming the viability line, the court justified that as having both a logical and a biological justification, that it marks the point in pregnancy when the fetus is capable of meaningful life.
No, that's what John Hart Ely explained was a complete syllogism. That's the definition of viability. It's not a reason that viability is a good line.
Well, it's focused on the idea of fetal separateness, and I think that that is a line that also accords with the history and tradition in this country of abortion regulation. Contrary to the state's arguments here, at the time of the founding and for most of early American history, women had an ability to access abortion in the early stages of pregnancy, and it was only when the fetus was deemed sufficiently separate the states could act to bar that. So I think that the viability line also aligns with history and tradition in that respect.
Justice Thomas?
You heard my question to counsel earlier about the woman who was convicted of criminal child neglect. What would be your reaction to that as far as her liberty, and whether or not the liberty interest that we're talking about extends to her?
Well, Justice Thomas, I have to confess that I haven't read the specific case you're referring to, but if I understand the question you were posing, it sounds as though the state is seeking to regulate for a child that's been born that was injured while it was inside the womb. And I think that we are not denying that a state has an interest there. We're not denying that a state has an interest here either. Roe recognized that states have interests that exist from the outset of pregnancy, but with respect to this specific right to abortion, there are also profound liberty interests of the woman on the other side of the scale. And not being forced to continue with a pregnancy, not being forced to endure childbirth, and to have a child out in the world. And the state's arguments here seem to ask this court to look only at its interests and to ignore entirely those incredibly weighty interests of the woman on the other side.
Thank you.
Justice Breyer? Justice Lee? No? Justice Gorsuch? Anything further?
I just want to make sure I understand your response to the Chief Justice. If this court were to reject the viability line, do you see any other intelligible principle that the court could choose?
Well, I think that it would be critically important, even if this court were to reject the viability line, to reinforce and reaffirm the fundamental and profound liberty interest at stake here. And
I'm sorry for interrupting, but that wasn't my question. I understand that point fully by the end of this argument. That is deeply clear to me. I understand your position. I'm just asking a question about whether you think there would be another alternative line that the government would propose or not. You emphasized that if 15 weeks were approved, then we'd have cases about 12 and 10 and 8 and 6. And so my question is there a line in there that the government believes would be principled or not?
I don't think there's any line that could be more principled than viability. I think the factors the court would have to think about are what is most consistent with precedent, what would be clear and workable, and what would preserve the essential components of the liberty interest. And viability checks all of those boxes and has the advantage as well as being a rule of law for 50 years.
Thank you. That's helpful, counsel. Appreciate it.
Justice Kavanaugh?
You make a very forceful argument and identify critically important interests that are at stake in this issue, no doubt about that. The other side says, though, that there are two interests at stake, that there's also the interest in fetal life at stake as well. And in your brief, you say that the existing framework accommodates, that's your word, both the interest of the pregnant woman and the interest of the fetus. And the problem, I think the other side would say, and the reason this issue is hard, is that you can't accommodate both interests. You have to pick. That's the fundamental problem. And one interest has to prevail over the other. at any given point in time. And that's why this is so challenging, I think. And the question then becomes, what does the Constitution say about that? And I just want to get your reaction to what the other side's theme is, and I've mentioned it in my prior questions. When you have those two interests at stake, and both are important, as you acknowledge, why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people being able to resolve this? And there'll be different answers in Mississippi and New York, different answers in Alabama than California, because there are two different interests at stake, and the people in those states might value those interests somewhat differently. Why is that not the right answer?
Justice Kavanaugh, it's not the right answer because the court correctly recognized that this is a fundamental right of women, and the nature of fundamental rights is that it's not left up to state legislatures to decide whether to honor them or not. And it's true, different rules would prevail throughout the country if this court were to overrule Roe and Casey, but what that would mean is that women in those states who are refusing to honor their rights and who are forcing them to continue to use their bodies to sustain a pregnancy and then to bring a child into the world will have no recourse other than to travel if they're able to afford it, or to attempt abortion outside the confines of the medical system, or to have a child even though that was not the best choice for them and their family.
Thank you.
Justice Barrett?
I have a follow-up to Justice Kagan's question about reliance. I'm just trying to nail down, and I asked Ms. Rickleman this question too, but I'm not sure that I fully understand the government's position or Ms. Rickleman's position. So on pages 18 and 19 of your brief, you talk about reliance interests, and you quote some of the language from Casey about a woman's ability to participate in the social and economic life of the nation. And I mentioned the safe haven laws to Ms. Rickleman, and it seems to me I fully understand the reliance interests. They're the airy ones Justice Kagan was referring to, and then there are the more specific ones about a woman's access to abortion as a backup form of birth control in the event that contraception fails, so that she need not bear the burdens of pregnancy. But what do you have to say to petitioner's argument that those reliance interests do not include the reliance interests of parenting and bringing a child into the world when maybe that's not the best thing for her family or her career?
I think the state is wrong about that, and I think where the analysis goes wrong in reliance on those safe haven laws is overlooking the consequences of forcing a woman upon her the choice of having to decide whether to give a child up for adoption. That itself is its own monumental decision for her. And so I think that there's nothing new about the safe haven laws, or at least nothing new about the availability of adoption as an alternative. Roe and Casey already took account of that fact, and I think that there are certainly, of course, all of the bodily integrity interests that we've referred to, but also the autonomy interests retain in force as well.
Okay, so it's the reliance interests in the right to be able to choose to terminate the pregnancy rather than having to terminate the parental rights.
I think that is part of it, yes, and I think for many women that is an incredibly difficult choice, but it's one that this court for 50 years has recognized must be left up to them based on their beliefs and their conscience and their determination about what is best for the course of their lives.
Thank you, General.
The reason I'm not talking much is because I really
rebuttal, General Stewart?
I'm trying to listen to it, but also
Thank you,
because I
Mr.
don't
Chief Justice. I'd like to do my best to make 3 points.
So nobody can
First,
pay attention. But if you
picking
guys
up
have
where
anything
you
to
just
say in
left
the
off, Justice
chat or
Barrett,
whatever,
on safe haven laws,
I'll bring it up.
The respondents in this case, I believe, as Your Honor pointed out, have emphasized parenting burdens being a lead or the lead reason that women seek abortions. I would emphasize safe haven laws, as best I've been able to find, first came into existence in 1999 in Texas. They're now ubiquitous, and you're correct, Justice Barrett, that they relieve that huge burden. I would also add that as to burdens during pregnancy, I would emphasize that contraception is more accessible and affordable and available than it was at the time of Roe or Casey. It serves the same goal of allowing women to decide if, when, and how many children to have. And I would also note, just frankly, the lowest cost abortion at Jackson Women's Health is $600 for the abortion. additional costs and further fees. According to my friends, the respondents and their amici, there are also additional costs related to travel, taking off time off
I don't
of work,
like this argument
accommodations,
that
all of those sorts
these
of
guys
things.
are making.
Whether somebody is
that-
uninsured or not,
well, there's still birth
the
control
costs of
and
contraception are
contraception.
consistently significantly less than those.
They're completely.
Number two, I think Justice Kavanaugh, you had it exactly right when you used the term scrupulously neutral.
So that
I think that's a very good description of what we're asking for here. I think it's the problem and the value that has evaded the court and will continue to evade this court under Roe and Casey. But that is exactly right. This is a hard issue. It involves, and I would emphasize, Your Honor, that as you said, there are interests here on both sides. There are interests for everyone involved. This is unique for the woman. It's unique for the unborn child, too, whose life is at stake in all of these decisions. It's unique for us as a society in how we decide, if the states get to legislate on this issue, how to decide and how to weigh these tremendously momentous issues. In closing, I would say that in his dissent in Plessy versus Ferguson, Justice Harlan emphasized that there is no caste system here. The humblest in our country is the peer of the most powerful. Our Constitution neither knows nor tolerates distinctions on the basis of race. It took 58 years for this court to recognize the truth of those realities in a decision, and that was the greatest decision that this court ever reached. We're running on 50 years of Roe. It is an egregiously wrong decision that has inflicted tremendous damage on our country and will continue to do so and take innumerable human lives unless and until this court overrules it. We ask the court to do so in this case and uphold the state's law. Thank you, Your Honor.
Thank you, General. Counsel, the case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
Oh, is that it? Did the lives of millions of babies just come down to that moment? Was that? Wow. Okay. Well, I thought they would motion for lunch and then come back and continue to argue, but I guess that was it. So but anyway, that was interesting. That was okay. Look, there's a lot of problems here. The first off, whoever it was, I think somebody said it was Kavanaugh that was doing the Plessy versus Jackson stuff, was really fantastic and whatnot, and like that argument is really the key and where everything should boil down to, I think. And like the other Supreme Court justices should have only emphasized that more. The question of whether a moral decision is immoral, can it be overturned? Should it be overturned? And not based on the arguments that both sides bring, just on whether the morality of it. I think that was a really powerful, probably one of the most powerful moments that I got to listen to of the thing. But the other thing that really bothers me is how the pro-life position is using contraception as an option. That is terrible, terribly frightening. Because we already see, like, RU-46. Do they consider RU-46 an abortion? Or do they consider that some form of chemical contraception? Right? And it's not going to be very difficult for them to move that to a chemical contraception sort of thing. They'll start pushing RU-46 over the counter. They'll start doing all sorts of things. And so that's really dangerous and concerning, I think, when the pro-life side becomes a coward in their defense. And I'm sure some of it's wisdom too, but I don't think it's the wisest, because it puts you in a position that can actually make things worse in the long run. I've talked about that before, about the decentralization of abortion through chemical abortifacients. That's a big fear. So I don't like it when I hear the pro-life side arguing for that. It makes me really, really nervous. And it makes me really nervous. But man, that Plessy versus Jackson argument was really, I think, where it centered. I don't think that Dobbs versus Jackson is going to be upheld by the Supreme Court. I think, let's see, it's a 6-3. It's 6-3, so there would have to be 2 from us that would turn. And my thoughts are that it would probably be well, obviously Justice Roberts is not a conservative, even though he's considered a conservative appointee. And then, yeah, it'll be interesting. I know Thomas is not gonna waive on this, so that'll be good. But I don't know where everybody else will. And really, for the conservatives on the court, we always talk about how this is a matter of, we have the conservative majority. Well, we've always had the conservative majority. We had the conservative majority during the last one in the 90s, and then we had a conservative majority for Roe v. Wade. So I like it's not about conservative majority. It's about courage and whether or not the Supreme Court justices that would identify as conservative, at least, have the courage to be able to really burn the entire country down, because that's what's going to happen if they were to overturn Roe v. Wade. And I don't think, based off of some of Amy Coney Barrett's previous decisions, which were kind of shocking, I don't think that there's really a Supreme Court that has courage. I just don't see it. And so we know the liberals where they're going to side, but it's always the conservatives that have to deal with courage. And that's where conservatives fail, I think, most, is their lack of bravery, their lack of ability to really be able to fight this. And I'm thankful, I guess, Jeff Durbin at Apologia is there in D.C. right now, which is pretty awesome. And I know that Bradley was able to actually write a document. I forget what you call it, but he was able to write an actual case to go before the Supreme Court that they have to read. And that sounded to me sort of where Plessy versus Jackson, the argument was coming from, was probably Bradley's. But I haven't read it, but if I had to guess, that is exactly where that argument came from. So I guess the only thing to really say is, man, just to be in prayer for the justices, not that they interpret scripture. Not that they interpret constitutional law accurately. I don't think constitutional law is really at the case here. It's just a matter of bravery and doing the right thing. And so I think, because even if there was a constitutional amendment in the Bill of Rights that said, as part of the Bill of Rights, women have a right to abort their child, as clear as day, they still wouldn't have that right. So it's not really a matter of, it doesn't even really matter what the Constitution says or how they interpret it or anything like that. What matters is just whether they'll be brave and do the right thing. And really, we talk about defy the Supreme Court, but when it comes down to this issue, it's really defy the Constitution, right? Like there are times where the Constitution is wrong, right? We saw that with Prohibition. That was a terrible, terrible amendment that was added to the United States Constitution. The inability for black people to vote was part of the Constitution, right? So at some point, the Supreme Court needs to defy the Constitution. But ultimately, of course, the states do too, if there's something immoral and wrong. And the Supreme Court needs to defy their own interpretation. So anyway, that's my thoughts on it. Probably not going to be the most popular thought, and I'm sure if I ever run for president, that clip will be pulled out, but I'll still stand by it, I'm sure. Because there's times where the Constitution has been wrong. There just has been. And so our morality isn't defined by the United States Constitution. Right and wrong isn't defined by that document. It's a good legal document. It's one of the best ever made. But it is not the final authority on all things. It is not the objective standard for morality at all. So, yeah. So, man, I was disappointed that went so short. But I guess it was probably going a lot longer in the morning. So, well, now I guess we just pray. We pray for Supreme Court justices to have courage and boldness and to do the right thing. But even if they don't do it, the states should ignore it. They should ignore the decision. You know, just like Plessy versus Jackson, obviously, the Fugitive Slave Act in Wisconsin, where the state of Wisconsin said we're not going to send slaves back to the South if they make it to Wisconsin. That was a complete defying of the Supreme Court. So it can happen. It can happen. But I wouldn't put my hope in it. I would rather we elect to just brave local officials who will defy the government, defy the feds, defy the Constitution, if need be. In that sense, defy the Supreme Court, and just stand up for what's right and to do what God requires of us. So again, guys, thanks everybody for watching. Thanks everybody for tuning in. And even if I was quiet most of the time, as my wife said. But anyway, have a great day.